Today. We've got Dayne Phillips here. Dayne Phillips is with the Phillips Law Firm. What's it called now, the exact name?
Well, it's certainly the Dayne Phillips Attorney at Law, but also working with Price Benowitz, who's a national law firm. Regionally, you got D.C., Virginia, and Maryland. They got a lawyer in New York, lawyer in Florida. Different.
So they can handle most up and down this coast.
That's right. And so now they have a lawyer based in South Carolina. It's a great firm, one that certainly has tremendous resources, and the cornerstone of that firm started with criminal defense, and since I'm a criminal defense attorney, it was a natural fit, and everything they do there is first class, so that part is great.
They're good. Now, if people come into you with a problem that's not criminal defense, can you make referrals based on who's available in that firm as well?
Absolutely. I mean, obviously, I'm the only South Carolina lawyer that's licensed in South Carolina for that firm. But obviously, the hope, the goals, is to grow that firm inside of South Carolina as well. But obviously, if someone comes to me with a real estate question or something like that, we can reach out to a lawyer that we have, or obviously if they need local counsel, that's where I find somebody that would, you like, know, and trust to make that referral so the person is well taken care of. Kind of the old adage is, if I can't handle your case, I will find somebody that I trust will handle your case the same way that I would.
Yeah, that's important. I tell people that when I advertise for somebody, I always think strongly about who I work with before I make a recommendation, because it's my name on the line when I recommend somebody.
Right, because if that person has a bad experience, the person they're going to think about is you, because you're the one who vouched for that person. So it's something, especially as an attorney, that you take very seriously, because it's very polarizing. People either have a great experience with an attorney or they have a bad experience. And if they have a bad experience with an attorney, it's something they never forget, and that's something that they kind of tell people the rest of their life, because generally when you're dealing with an attorney, you're dealing with, for the most part, something that's one of the most important things that's ever going to happen in your life.
Sure. And even if it's not a crime, if it's a real estate deal. In fact, we talked about one in Chapin last night. Strangest thing, a kind of a beautiful little strip shopping center with a lot of businesses in it. All those are deeded to business owners or different property owners, but the parking lot was actually deeded as common land, and whoever had that common land quit paying the taxes on it. So a year or so ago, the county took it and sold it for the taxes. So now, technically, I think the way I understand the real estate law and the way we were talking about it yesterday at a meeting in Chapin, the guy that owns if a year goes by and it's his parking lot, he could start putting up meters and charging people to park in the parking lot, or tell them stay out my parking lot. And all those businesses would have no parking places. Right.
I mean, think somebody has a real estate question. That's one of the biggest transactions you're ever going to do in your life is buy a home. If you have a will, that's something you're wanting to set up, a life estate for your family when you pass. If the divorce obviously is something that's going to be
very heated.
If you have children, that working out the custody issues. I mean, an attorney's role is generally coming in at a point that's one of the most important times of your life, and you need to have that personal attention, and you need to have somebody who's competent and who's got your best interest at heart.
And we've talked about the fact that it's a crapshoot if you don't get good advice, because you can find bad ones out there just as easily.
It's like any profession that's out there. Obviously, there's plenty of lawyer jokes, but there are many great attorneys out there. But on the flip side of the coin, there are many, just being frank, attorneys that I would say you need to be very wary of and watch out for, because the outcome of these life-changing events could be determined based on the attorney you chose.
We've talked about law enforcement kind of using what I call a sweat technique to get people to plead guilty to something quickly without having to go through a trial. They'll leave them sitting in jail. They know they can't make the bond, and they'll just leave them sitting there to the point that they're ready to plead guilty to anything if it means time served and I can get out now. And there's also attorneys that will take that case and really not work on it, just let you sit there and marinate until you'll say, I'll plead guilty to anything and you can keep my money.
Well, going directly to what you just said, I shared an article on Facebook the other day where the National Registry of Exonerations, people that were found essentially, they were convicted, found guilty, but then later proved innocent. So there was 397 people that's on the National Registry of Exonerations who pled guilty. So these are people who admitted guilt in court, pled guilty, but then were later proven innocent.
Just because
it's a systemic problem that we have in our country. Roughly 94-95% of state cases are guilty pleas. In federal court, it's almost up to 97-98%.
Wow.
And it's just the way this, and I could explain that later as far as why there's the discrepancies. But I mean, even if you average that out, say 96% or so 96 out of 100 cases are pleading guilty. And there's many different reasons why, and most of them are systemic problems. Overcharging, we need bond reform. People are sitting in jail languishing because they can't bond out, so they plead guilty to get out of jail versus whether they're actually guilty of the charge. I mean, there's many different reasons why. If somebody's facing 100 years, but the prosecutor says that, I'll give you a sweetheart deal kind of thing, or even if it's not that sweetheart, but at least it's not you spending the rest of your life in prison. Someone who's innocent is now put in a position where they have to make a very tough decision of, do I roll the dice, do I make that gamble, go to trial and then possibly lose my whole life in prison, or do I accept this deal, have this scarlet letter of a conviction on my record, but I know that it's a guarantee that it's something I can live with, and that's something that people battle with on a daily basis.
It's funny you say that, because I know that a number of years ago, the sheriff, the 11th Circuit solicitor, the magistrates, and the public defenders had a committee together that were the whole purpose was to decrease overcrowding at the Lexington County Detention Center. And they got there and they formulated a plan on how to do that. And that brought about a lot of guilty pleas where they were working things out on nonviolent offenders. And yet we still have a jail that's traditionally overcrowded, and we still have a court backlog. How do we have a court backlog if 90+% of people are pleading guilty?
So I think the Lexington County Detention Center holds roughly 800 people, give or take. I've always heard around 700 people. And so as far as the jail overcrowding, a lot of that's going to be related to drug offenses, small magistrate court related offenses. The bulk of the people in there are not major felony cases. It's the run-of-the-mill DUS, and it's a lot of repeat offenders for the traffic related offenses. And
we just did a story once this morning, a guy DUS third, habitual offender.
I saw it. And so, I mean, that's something that just happens over and over and over in the habitual offender part of it. And as far as small property crimes, a lot of repeat offenders with that, and of course the drug epidemic that we have in Lexington County with methamphetamine and most recently opioids. I mean, the possession of controlled substance and heroin is just it's the entire United States. It's not limited to Lexington County. But as far as the backlog, although there's all these guilty pleas, there's just that many cases, and there's different ways to attack it, and one of that would be as far as moving the backlog to a more manageable number. I would say, to be honest with you, somehow we're going to have to try to find a different way to enforce drug offenses. That would be probably step one. I mean, I couldn't think of another thing to address first on the backlog other than some type of reform for drug offenses. Even a step removed from that, I would say one of the first things that needs to happen is good bond reform. I think that would help as far as due process and making sure people are obviously presumed innocent when they are arrested, and we need good bond reform, I'd say.
We still have a lot of people who think that bonds are punitive and they're not just to ensure that somebody's going to return to court. I mean, I told somebody here last week when we put some there was a story that came out about a father who shook a child till it permanently injured that child's brain, and I said, when I put this story up, the mothers are going to scream that he got out on a $25,000 bond because they think that the bond is the punishment, and it's truly not.
And like we've talked about before, and I've seen many of attorneys not really read the statute and argue all kinds of different things at a bond hearing. A presiding judge at a bond hearing is really only looking at a few factors. One is whether the bond amount that they would pose would reasonably assure the appearance to court. In other words, are they a flight risk? Do you believe they would run? Would they try to escape prosecution, flee prosecution? And then if I set a bond amount, would I believe that would be enough that the surety bond, would be hanging over their head through the bondsman, that they're going to appear in court? They're not going to risk the consequences of that, skipping out on that bond to show up to court. And then the second thing would be whether they pose an unreasonable, and the key word is unreasonable. A lot of people just say danger to the community. The statute actually reads unreasonable danger to the community or a specific person. And a lot of times there's not evidence that they pose an unreasonable danger. I mean, unreasonable is a high standard. Now, danger to the community could be a low standard, but unreasonable danger to the community. And then they have a set list of factors as far as, strong ties to the community. So did you live here for the risk of flight? Did you live here your entire life? Is your job here? Is your family here? Here are all the factors to show where you, if you're from New York, and you spent your whole life in New York, you just moved down here, you have no family here, you have no job here, and it's a major felony, you'd be considered a possible flight risk because you have no ties.
Sure, that's the story we did about the gangbanger from Chicago that Chapin police got. They stopped at the rest stop out there. He beat the poop out of his girlfriend, tried to throw a concrete flower pot through the front window, threatened the life of one of the police officers. He was from Chicago going to Fort Jackson for a graduation. He doesn't need to be out of bond.
Right, so at a bond hearing, one of the things I try to make sure the magistrate or circuit court judges, depend on where you have in the bond hearing, they understand, because a lot of times, because the attorneys don't argue it right, in my opinion, a lot of them, that's their focus. It's two things, really, and there's factors under both that they look at, but outside of those things, the person's presumed innocent. We can't sit here and try to decide the person's guilt at a bond hearing. The whole purpose is whether they'll appear in court and whether they'll pose a danger if they're out, an unreasonable danger to the community.
Yeah, well, let's get back around to this now then, because you've been accused of a crime. You're going to have a bond hearing within a certain amount of time, correct?
So in South Carolina, you're required to have a bond hearing within 24 hours of your arrest. The Chief Justice, Donald Beatty, actually put out a inclement weather post yesterday for all of the lawyers and court staff throughout South Carolina. And one of the things he noted that although he said for presiding judges to give lawyers some leeway on if they're coming from a county that had severe inclement weather on continuances and showing up on time, that he still had a directive to the chief magistrate judges that unless you need to have it to where, and he phrased it in such a way where you're going to have at least one bond hearing in that 24 hours unless it's absolutely impossible. Because our South Carolina law requires a bond hearing within 24 hours of arrest.
All right, so, and yet there's a lot of people that don't have an attorney at the bond hearing. Why?
Most. They just don't.
Why?
One, it's because 24 hours is a quick amount of time. I think if you had a bond hearing a couple days later, most people would have an attorney, or at least people that could afford an attorney would have an attorney at the bond hearing. But because it happens so fast, most people can't even wrap they're overwhelmed, they're stressed, the family's basically freaking out trying to figure out what's happening, and the bond hearing happens very quickly. If you get arrested overnight, it's common in Lexington County, you're going to make the 10 o'clock in the morning bond hearing, and then you got the next one at 3 o'clock. I mean, it's moving quick. And because it's so quick, it's the expediency of it. It's happening so fast.
All right, how about money? I mean, I have a home, I have a car that's paid for, I live off of my retirement. I don't have a lot of money. I don't really have a lot of cash put back. But do I have to quit making my house payment to pay my attorney? Or can I file to get one?
So what happens at the bond hearing, and of course it can happen later, but where you're initially screened at the bond hearing, what's called screening, is whether you can afford an attorney or not. So that's part of the process. The judge will ask you what property do you own, how much money do you make, what type of job you have, and there's an actual, under the law, a grid of how what the threshold amounts are to make, and if they feel that you've made those requirements, then you'd be approved for a public defender. What happens a lot of time is there's a big group of people who are kind of on the bubble, and then they can't they get denied a public defender at the bond hearing, and then later down the road they show up to court and say, look, I can't afford an attorney, and then what happens is they get sent to the public defender's office to be screened separately. They got to fill out what they call an affidavit of indigency, where they say, here's what I make, here's the property I own. It's filed with the clerk of court's office, and then they're generally approved, because there's not a whole lot of oversight with it.
So they, I mean, if it does come down to me making my house payment or keeping my electricity on for my children or hiring a lawyer, at some point I can keep making my house payment and keeping the electricity on, and I may be okay.
And that's where, yes, and that's where the oversight comes in. Because there's virtually no oversight, most people are not going to be in a position to where they're going to be denied in those circumstances. Now, in your case, if you declared you got X amount on retirement, if you told the truth on that affidavit of indigency, they probably would deny you. I mean, if you probably made the threshold amounts to be declared indigent are very low. Yet, and probably in Lexington County, 85% of the cases are indigent cases. Criminal cases are indigent cases. The public defender's office probably has 85 out of 100, give or take, of the criminal cases.
Now, I mean, everybody looks down on public defenders. I mean, they say you get what you pay for. If you pay nothing, you don't get nothing. But are there some good public defenders out there?
There's some amazing public defenders out there. I mean, it's a job where you're overworked, underpaid, underappreciated a lot of times. You have kind of the whole system against you. You don't have those resources. The problem is it's routinely, most public defenders have well over 100, if not pushing 200 or over 200 cases at any given time. You get scheduled for multiple trials, and the ability to prepare the way you need to is limited because of the sheer amount of volume of cases you have. That's the problem. And then, of course, being underpaid. And, of course, you got people who sometimes are straight out of law school, and it's an amazing training ground for a criminal defense attorney because you're going to get a lot of experience. You have a credible amount of cases at once, and you're going to see a lot of different things to be exposed to. But, again, if you got a murder case, you don't necessarily want somebody that's right out of law school. Luckily, in Lexington County, that doesn't happen. It's not that way. But there are parts around the state where I've seen public defenders within 1 year of practice around the state try a murder case in their first, second year out, and that's scary.
Yeah. Now, I mean, we look at like the Dylan Roof case. I mean, at what point does it become such a high-profile or heinous act that the state pops for the big dogs? I mean, the big names.
So it's that's because he was charged. That was in his federal case. Now, in federal court, the federal judge appointed David Bruck, which is what you'd say
nationally renowned.
Right. He is even though he is from here. I mean, locally, it's not like they brought in some guy from New York. I mean, David Brooks went to University of South Carolina School of Law, but he is nationally known for representing high-profile death penalty cases. So he was kind of a natural fit to be appointed. And on the state level, we have, and I think we discussed this before, we have what they call the capital trial division. So if there's a death penalty case, there is I believe it's 3-lawyer team, and then of course, because I don't think they've added any, so I know the 3, and their whole job is essentially like they are death penalty public defenders. They just call them capital trial because capital is for death penalty, and if there's a state level death penalty case, they were on the Dylan Roof case as well, they're just on the state level. And so when you have a death penalty, virtually 100% of death penalty cases at the state level are going to be handled by these capital trial, these death penalty public defenders.
And a lot of people don't understand the concept or even how much goes into this, but I've heard Rick Hubbard talk about the war room and this huge conference table covered up with files and boxes of evidence and we talk about full-size legal pads, and if you ask a young person nowadays to write that much, they feel like they've had a tough day, and we're talking about legal pads literally full of notes, one after another, in some sort of case like that. We're talking about lots and lots of preparation.
So, yeah, an average death penalty case is going to take years to prepare. well over $1 million, could be into multiple millions of dollars. So when a solicitor makes that decision, because it's ultimately the decision to seek death penalty, because they have to submit a notice. It's ultimately up to the sitting solicitor for that circuit.
And ours recovered here.
Recovered. So you got to make that decision, submit the notice, and when you do that, I mean, that's saying that the county as a whole has made the decision, as the chief prosecutor, that they're going to pursue it, and there's a lot that comes with it. I mean, millions of dollars are put into a death penalty case.
Well, how much does your attorney have to listen to you? I mean, if you get partial of the way through this thing and you just say, this guy's not working, he's not listening to me, how much control do you have over your case?
So all the legal issues, motions, that kind of thing, it's left up to the lawyer himself. Now, the client gets to make the decisions of whether to plead guilty, go to trial, make basically the very constitutional right decisions about whether to plead guilty or go to trial. All legal decisions are left up to the lawyer, and that's the way it's set up. Now, if you disagree with the lawyer's decision whether to file a motion, whether to do certain things, and you feel like what they call you've had a material breakdown of the relationship, basically, in other words, you just can't get along, then you'd have to go before a judge and ask to have the lawyer relieved as counsel to get a new lawyer. A lot of times what happens if somebody can afford it is they just go to a new lawyer, hire that new lawyer, and they do a motion to substitute counsel, and you just switch them out. But if you're indigent, most of the time, if you're represented by the public defender's office, if you're poor, most of the time you have to go before the judge and say, we're not getting along, to where it's not beneficial to the client because of the relationship. And if the judge thinks that it's to that level, then they will relieve the attorney and give them a new attorney. It's rare, though. Judges are very reluctant to do that because for appointed cases, they don't want it to feel like you have necessarily the absolute right just to fire and have whoever you want, that it's got to be a true material breakdown of that attorney-client relationship.
And that's something you have to show evidence of. You go in and you say, he and I have fought and argued on every point. And
pretty much, yes. And especially if it's going to trial, that's where you see a lot of them, where somebody wants to go to trial and they're just not seeing eye to eye with their attorney. And because it's going to trial, the judge knows he's got to treat it differently, in the sense that if the attorney and client are not getting along at all, how can they go through a trial together? How could they be adequately prepared for trial if they're not seeing eye to eye on anything?
Right, and so let's talk about witnesses and going to trial for a moment. Occasionally you hear terms like hostile witness. What's the difference between a witness and a hostile witness?
So a hostile witness is essentially, and you can ask basically it's a rule to lax the rules of evidence. It's where you ask the judge, can this person be treated as a hostile witness? In other words, I can ask leading questions to a witness that I would normally would be confined to only ask non-leading questions. So if it's you call the witness, all right? And so if I said I'm calling Paul Kirby to the witness stand, and because you're my witness, I'm not allowed to ask leading questions. In other words, I can't ask a question that would imply the answer.
Like, didn't you do that last night?
Yeah. Anything that would basically end in a yes.
Weren't you there yesterday afternoon?
Right. Anything that would end in a yes is a leading question, pretty much. So I'm not allowed to do that because you're my witness. Because I could just feed you all the answers I want you to say. But once you turn into a point where you're not answering my questions, I could ask the judge, can we treat the witness as a hostile witness? And if the judge says yes, then I can now treat it like cross-examination. And cross-examination is 180 turn. All you ask is leading questions. The only answers you want are yes and no. And that's where I can then pelt you with leading questions.
I got you. So, and that occasionally does happen.
It does.
If you've called a witness and somehow the witness has now become reluctant to help with the case?
It happens all the time.
All right, so how much do you have to help? If I see a crime, we see now with the advent of the internet, we did that story this morning about a police officer using the internet to apprehend a stolen car and that young man. With the advent of the internet now, we see more and more crimes being committed and people turning their back and walking away, or people standing there and videoing it while it's occurring. How much do you have a responsibility as an American to testify?
So, Two things. So one, there is a statute on board that if there is an accident, if you get in an accident with somebody and they're hurt, seriously hurt, you have a duty to render aid.
Right.
So you can't just leave that person to die. So that's kind of a separate matter. But so there are instances where you have a duty to aid. Now, on the kind of on a different level, as far as a witness, once you receive a subpoena, that's a court order. So if
it's not a suggestion,
right?
It's an order. I always like to tell people that.
Right. You get served a subpoena to be in court. That is a court order that says you will either be in court or a bench warrant can be issued for your arrest, and we'll
drag you
to court. We'll make sure you show up. And police can come get you. Now, you show up in court, you get called to the witness stand, and you refuse to testify on matters. If you're under subpoena, a judge could then hold you in contempt of court and lock you up. So,
what if you say I plead the fifth? Do you have to prove that you know enough that it could incriminate you, or can you just say I plead the fifth?
Now, you could plead the fifth.
Which means you have the right not to self-incriminate yourself.
Right. And depending on the circumstances, the judge could still hold you in contempt. But you have the right not to testify. They can't force you to testify. But they could still hold you in contempt, and that would be up to the judge's discretion.
Now, I've always heard that you cannot be forced to testify against your spouse. Is that correct?
So there is a spousal privilege in South Carolina, but there are some caveats to that. So they can't force you to testify against your spouse, but it's a privilege that the spouse has to elect. So if they call your wife to the stand, she has to be the one to say, I'm electing the privilege. You can't elect the privilege for her.
So if she's ratting you out, you can't say, wait a minute, you can't tell on me.
It's her privilege to waive.
I got you.
There's a couple more caveats. The other one is if the crime involves children. So if there's some type of physical abuse or sexual abuse, the spousal privilege is gone.
She better tell, or he better tell, or
she can't waive it. And then the other instance that came up, I want to say it's State v. Govan is the case on point, where it was a domestic violence case. They said, look, we're going to raise the spousal privilege, and the whole point was that the court, if I'm stating it correctly, would be that spousal privilege doesn't apply to conduct. It applies to confidential communications. In other words...
So if she saw him do it, it's one thing. If
right.
he said, I did it, that's another.
Right. So if it was, did he hit you, that's not a confidential communication. That's not something they've talked about and is between them. That's conduct. So it doesn't apply basically to domestic violence in such a way as far as the conduct's concerned.
But if they're in bed and he says, I hit John and John hit his head on the curb and never got up, that is confidential.
She could elect not to testify against him.
Is there anybody else that is privileged in that way in your family? I mean, if you see your children commit a crime, or if one of them comes in and says, hey, Dad, I stole the car, or I...
To my knowledge, there's not. Only the spousal privilege.
So just, is it common law? I mean, and that would make it sticky. I mean, a lot of people have been together for 25 years and never legally got married.
So, right. So whether you're common law married or not would be a question that could be raised to the judge and it'd be a legal issue to throw up there. Again, to my knowledge, I don't think a common law marriage case on the spousal privilege has gone up to our appellate courts. So I think it's an open, what they call a novel issue. It's an open question. I mean, if there is one out there, there may be one case, but it's something I've never seen. So to my knowledge, that issue has never been addressed by our appellate courts. As far as common law marriage, spousal privilege,
interesting.
There could be a case out there. I've never seen it.
That's interesting because, I mean, we do have a lot of people nowadays. I had a couple that worked for me, and I actually at the time was a notary and finally did their wedding ceremony. They'd been together 22 years, had 3 children,
right,
and just never got married for some reason, And so, I mean, everybody thought they were married, but they just never had the ceremony and the official presiding. So
I have to do the research on that for you.
To see. All right, well, sometimes you'll hear them say, Your Honor, I'd like to have the charges dismissed. dismissed, even before the prosecutor gets their chance to present their case, and it becomes the defense attorney's time to stand up and say that. He says, I just don't think that the prosecutor has even presented enough evidence here. I'd like for you to dismiss it at this point. What is dismiss with prejudice?
So dismiss with prejudice means the charges cannot be refiled against you. That it is over. There's no new information that's going to come up. There's none of that. The charges are dismissed. That is final. Dismissed without prejudice means the solicitor could easily file to have the prosecutor could easily file to have the charges reopened.
And it may be because a prosecution witness didn't show up, or
many different
something
reasons.
Different happened. I know a lot of times that defense lawyers will put off trials and put off trials and put off trials because people retire, people take other jobs, and police officers take other jobs, and it's hard to find witnesses after a period of time. If it gets to the point when the prosecution case gets that weak, you can say, I'd like to have it dismissed with prejudice, meaning it goes away, and if that guy shows back up, tough luck.
Right, so if it's dismissed with prejudice, then you could pursue to have it expunged.
Okay.
Dismissed without prejudice, you run into a difficult problem, because then, they could always bring the charges back up.
What about double jeopardy? What if you're found innocent of, say, attempted murder or second-degree murder, and instead they turn around and charge you with voluntary manslaughter?
So in South Carolina, the best way to describe it is, so we only have murder. There's no degrees of murder.
Okay.
And to get a little bit of legal on you, so what they call, there's a Supreme Court case from the United States Supreme Court called Blockberger, and basically what they say is, if the charges, it would be considered a lesser included offense. In other words, that they have the same elements to prove, and once the jury is sworn on that,
I did.
right. So basically, where murder is very specific, and then you have the lesser included offenses of it. So again, it gets to be a very sticky situation whether or not they want to pursue another trial on additional charges. But the bottom line is, if you have a charge and there's lesser included offenses under it, once this charge you've been found not guilty, anything that would fall under it, they basically re-indict you on it and try to prosecute you later. However, if there is another charge that doesn't directly fall under it, then they could try to pursue it if they had the competent evidence to move forward on another indictment. I've seen this in a couple of instances, and I think it's outrageous. I think if they've had their one bite at the apple, they shouldn't be able to come back because they forgot to add a charge. But technically they could.
So it becomes, again, a sticky situation whether you don't know exactly how things are going to turn out.
Well, it's one where it depends on what you're charged with. It depends. You need to sit down with your attorney. Any good criminal defense attorney is going to sit down with you when you're preparing for trial and say, all right, here are the things you need to know, and here are the things that if we get a not guilty, you're never going to have to worry about ever again. And here are the things that you could have to worry about. In most cases, you don't have anything to worry about if you get a not guilty. But in some cases, the prosecution could still try to come after you on something else.
If somebody's accused of a heinous crime like murder, do you ever get face-to-face with that person? I mean, when you go to the jail, do you sit there and have to talk on the telephone and look at them on the screen? Or can you sit down and spread out what you got on the table and show them and talk to them about it and show them pictures?
So as a criminal defense attorney, I have an absolute duty to meet with them and review all their evidence. Yeah, well, it depends on how the jail's set up, but that's on me. So if your attorney never meets with you face-to-face, it depends on which type of jail you're at and how they got it set up for the attorney visits. But say in Lexington, the normal attorney rooms, there's a piece of glass and then a little space at the bottom we can pass papers. But if I wanted to, and I have for other reasons where you want to put out all the paperwork and be able to have more of a back and forth,
and show it all out on the paper.
They have a little side room in the pods in Lexington County Detention Center, and as long as I sign the waiver that if I get hurt, it's on me, I can go back and you and I can sit down and talk as long as we need, face to face, at a table, not in a room where there's any partition or anything like that. So again, it depends on which jails you're at, because they have different rules in each jail. I mean, I haven't been to one jail where they've done everything the exact same. Each jail's kind of laid out differently. Each jail has different rules and procedures for how they follow that. But again, when it comes down to preparing for trial, if somebody's incarcerated, if somebody's in jail, yes, we're going to have a face-to-face sit down, and we're going to put out all the evidence. We're going to prepare for trial. We're going to review everything.
Right. So now, and just out of curiosity, oftentimes the way somebody's dressed, I mean, I've been to magistrate court, and you see them march guys in belly chains with their hands cuffed and their feet cuffed and in orange jumpsuits for, I mean, even writing bad checks at the IGA. And they come in. I mean, to me, it's very prejudicial to see them that way. How do you prevent that from happening in a big trial? So
the United States Supreme Court, there's a case directly on point. Without a doubt, you cannot be sitting there at the table at trial in jail garb and chains. It's shackles, essentially, is the way it's listed in the case. A jury cannot see a person accused of a crime on trial in shackles. Then you get a new trial in a heartbeat if that happens. And so, but if they're a dangerous person, what do they do? So, the crime itself is not considered. So it could be a heinous murder. That doesn't mean they can have you shackled. Now, what they do to get around that, I've seen multiple things. They've put say somebody's actually done something, and they know that they pose a danger to court staff and everybody. They've showed out before. I've seen them where they've put basically a runner, so to speak, around the table, so the jury can't physically see the person having the shackles, and they could have the normal clothes on, but they wouldn't see under the table where they have the shackles. Yeah, like a tablecloth. Exactly. And the other thing that they do, and what I think's the best way to prevent having a mistrial, is they call it a stun belt. I've seen that. And it's basically a metal belt that goes around your waist, and there'll be a deputy that sits 5 feet away from you who's already going to be there anyway, but he has a little remote control, and if you stood up to show out, he hits the button, and it's a stun gun, but it's a belt that goes around your waist, and it will bring you to your knees in a heartbeat. Yeah, and it's under your clothes. Nobody would see it. No slight to court officers, but a lot of them are in the twilight of their career, and they're not the youngest. And I mean, those are the guys out chasing down folks on foot. Well, so I mean, if somebody's really dangerous, it can get kind of hairy. Well, a lot of times, so there's the difference. You got the bailiffs who wear the red jackets, and they're generally the older fellows. But then you have courtroom deputies who are, deputies from the Lexington County Sheriff's Department. But what I'll tell you is, the belt's not showing; it's under the clothes, and that's the best and most reasonable way to handle that situation. Right. We are out of time. If you have questions for Dayne, you can always email them to me at thelexingtonledger.com. But Dayne, tell them right now how to get a hold of you if they need you. Well, you can call my office at 803-272-4503, or you can call me directly on my cell phone at 803-807-0234. Certainly appreciate being here. Again, everything that I say is just general information. It can't be legal advice in this term. If you need legal advice, schedule a meeting with me. And where your office is downtown now, right? Close to the courthouse? Right. I have a satellite office here over there on Butler Street here in Lexington. So I do have a local office here in Lexington, but I'm also on Taylor Street at 1614. I'm on Suite D, right there near the township, about half a block from the township. But would be glad to sit down and speak with you if you do have a legal matter that you want to discuss further. And Dayne, we appreciate you coming, as we always do. It's always a lot of fun. Dayne's one of our most popular guests to come in. I know he's got to rush off this morning to go to court, so we won't stretch this out, but Devin will put up his phone number where you can get a hold of him. Remember that a man who represents himself in the court has a fool for an attorney, so make sure you call a good attorney. And Dayne certainly is a good one. For the Ledger, as we say every day, we love you and we love Lexington County. Good day and God bless from Good Morning Lexington County. Thank you for having me.